Part 3. Elaboration of certain rights. 79 Application of Part 3. 1. This part elaborates certain rights and freedoms to ensure greater certainty as to the application of those rights and freedoms to particular classes of people. 2. This part must not be construed as limiting any right or freedom set out in Part 2. 80 Rights of Women. 1. Every woman has full and equal dignity of the person with men, and this includes equal opportunities in political, economic and social activities. 2. Women have the same rights as men regarding the custody and guardianship of children, but an Act of Parliament may regulate how those rights are to be exercised. 3. All laws, customs, traditions and cultural practices that infringe the rights of women conferred by this Constitution are void to the extent of the infringement. 81 Rights of Children. 1. Every child, that is to say every boy and girl under the age of 18 years, has the right a. to equal treatment before the law, including the right to be heard. b. to be given a name and family name. c. in the case of a child who is born in Zimbabwe, or 2. born outside Zimbabwe and is a Zimbabwean citizen by descent, to the prompt provision of a birth certificate. d. to family or parental care, or to appropriate care when removed from the family environment. e. to be protected from economic and sexual exploitation, from child labor, and from maltreatment, neglect or any form of abuse. f. to education, health care services, nutrition and shelter. g. not to be recruited into a militia force or take part in armed conflict or hostilities. h. not to be compelled to take part in any political activity, and I. not to be detained except as a measure of last resort and, if detained, I. to be detained for the shortest appropriate period. 2. to be kept separately from detained persons over the age of 18 years, and 3. to be treated in a manner, and kept in conditions, that take account of the child's age. 2. A child's best interests are paramount in every matter concerning the child. 3. Children are entitled to adequate protection by the courts, in particular by the High Court as their upper guardian. 82 Rights of the elderly. People over the age of 70 years have the right a. to receive reasonable care and assistance from their families and the state. b. to receive health care and medical assistance from the state, and c. to receive financial support by way of Social Security and welfare. And the state must take reasonable legislative and other measures, within the limits of the resources available to it, to achieve the progressive realization of this right. 83 Rights of persons with disabilities. The state must take appropriate measures, within the limits of the resources available to it, to ensure that persons with disabilities realize their full mental and physical potential, including measures a. to enable them to become self-reliant, b. to enable them to live with their families and participate in social, creative or recreational activities, c. to protect them from all forms of exploitation and abuse, d. to give them access to medical, psychological and functional treatment, e. to provide special facilities for their education, and f. to provide state-funded education and training where they need it. 84 Rights of veterans of the liberation struggle. 1. Veterans of the liberation struggle, that is to say, a. those who fought in the War of Liberation, b. those who assisted the fighters in the War of Liberation, and c. those who were imprisoned, detained or restricted for political reasons during the liberation struggle, are entitled to due recognition for their contribution to the liberation of Zimbabwe, and to suitable welfare such as pensions and access to basic health care. Part 5. Limitation of fundamental human rights and freedoms. 86 Limitation of rights and freedoms. 1. The fundamental rights and freedoms set out in this chapter must be exercised reasonably and with due regard for the rights and freedoms of other persons. 2. The fundamental rights and freedoms set out in this chapter may be limited only in terms of a law of general application and to the extent that the limitation is fair, reasonable, necessary and justifiable in a democratic society based on openness, justice, human dignity, equality and freedom, taking into account all relevant factors, including a. the nature of the right or freedom concerned, b. the purpose of the limitation, in particular whether it is necessary in the interests of defense, public safety, public order, public morality, public health, regional or town planning or the general public interest. C. The nature and extent of the limitation. D. The need to ensure that the enjoyment of rights and freedoms by any person does not prejudice the rights and freedoms of others. E. The relationship between the limitation and its purpose, in particular whether it imposes greater restrictions on the right or freedom concerned than are necessary to achieve its purpose, and F. Whether there are any less restrictive means of achieving the purpose of the limitation. 3. No law may limit the following rights enshrined in this chapter, and no person may violate them. A. The right to life, except to the extent specified in Section 48. B. The right to human dignity. C. The right not to be tortured or subjected to cruel, inhuman or degrading treatment or punishment. D. The right not to be placed in slavery or servitude. E. The right to a fair trial. F. The right to obtain an order of habeas corpus as provided in Section 57A. 87 Limitations during public emergency. 1. In addition to the limitations permitted by Section 86, the fundamental rights and freedoms set out in this chapter may be further limited by a written law providing for measures to deal with situations arising during a period of public emergency, but only to the extent permitted by this section and the second schedule. 2. A written law referred to in subsection 1, and any legislative measures taken under that law, must be published in the Gazette. 3. Any limitation which a written law referred to in subsection 1, imposes on a fundamental right or freedom set out in this chapter must not be greater than is strictly required by the emergency. 4. No law that provides for a declaration of a state of emergency, and no legislative or other measure taken in consequence of such a declaration, may a. Indemnify, or permit or authorize an indemnity for, the state or any institution or agency of the government at any level, or any other person, in respect of any unlawful act, or b. Limit any of the rights referred to in Section 86(3), or authorize or permit any of those rights to be violated. Chapter 5. The Executive. Part 1. Executive Authority. 88 Executive Authority. 1. Executive authority derives from the people of Zimbabwe and must be exercised in accordance with this Constitution. 2. The executive authority of Zimbabwe vests in the President who exercises it, subject to this Constitution, through the Cabinet. Part 2. The President and Vice Presidents. 89 The President. The President is the head of state and government and the Commander-in-Chief of the Defense Forces. 90 Duties of President. 1. The President must uphold, defend, obey and respect this Constitution as the supreme law of the nation and must ensure that this Constitution and all the other laws are faithfully observed. 2. The President must a. Promote unity and peace in the nation for the benefit and well-being of all the people of Zimbabwe. b. Recognize and respect the ideals and values of the liberation struggle. c. Ensure protection of the fundamental human rights and freedoms and the rule of law, and d. Respect the diversity of the people and communities of Zimbabwe. 91 Qualifications for election as President and Vice President. 1. A person qualifies for election as President or Vice President if he or she a. Is a Zimbabwean citizen by birth or descent. b. Has attained the age of 40 years. c. Is ordinarily resident in Zimbabwe, and d. Is registered as a voter. 2. A person is disqualified for election as President or Vice President if he or she has already held office as President under this Constitution for 2 terms, whether continuous or not, and for the purpose of this subsection 3 or more years' service is deemed to be a full term. 92 Election of President and Vice Presidents. 1. The election of a President and 2 Vice Presidents must take place within the period specified in Section 158. 2. Every candidate for election as President must nominate 2 persons to stand for election jointly with him or her as Vice Presidents, and must designate one of those persons as his or her candidate for first Vice President and the other as his or her candidate for second Vice President. 3. The President and the Vice Presidents are directly elected jointly by registered voters throughout Zimbabwe, and the procedure for their election is as prescribed in the electoral law. 4. The qualifications for registration as a voter and for voting at an election of a President and Vice Presidents are set out in the 4th Schedule. 5. The election of a President and Vice Presidents must take place concurrently with every general election of members of Parliament, provincial councils and local authorities. 93 Challenge to presidential election. 1. Subject to this section, Any aggrieved candidate may challenge the validity of an election of a president or vice president by lodging a petition or application with the Constitutional Court within 7 days after the date of the declaration of the results of the election. 2. The election of a vice president may be challenged only on the ground that he or she is or was not qualified for election. 3. The Constitutional Court must hear and determine a petition or application under subsection 1, within 14 days after the petition or application was lodged, and the court's decision is final. 4. In determining a petition or application under subsection 1, the Constitutional Court may a. Declare a winner. b. Invalidate the election, in which case a fresh election must be held within 60 days after the determination, or c. Make any other order it considers just and appropriate. 5. If, in a petition or application under subsection 1, a. The Constitutional Court sets aside the election of a president, the election of the president's 2 vice presidents is automatically nullified. b. The Constitutional Court sets aside the election of either or both vice presidents, the president must without delay appoint a qualified person or qualified persons, as the case may be, to be vice president or vice presidents. 94 Assumption of office by president and vice presidents. 1. Persons elected as president and vice presidents assume office when they take, before the Chief Justice or the next most senior judge available, the oaths of President and Vice President respectively in the forms set out in the third schedule, which oaths they must take. A. On the 9th day after they are declared to be elected, or b. In the event of a challenge to the validity of their election, within 48 hours after the Constitutional Court has declared them to be the winners. 2. The incumbent president continues in office until the assumption of office by the president-elect in terms of subsection 1. 3. A vice president who becomes president on the death, resignation or removal from office of the president assumes office when he or she takes, before the Chief Justice or the next most senior judge available, the oath of president in the form set out in the third schedule, which oath he or she must take as soon as possible and in any event within 48 hours after the office of president became vacant. 95 Term of office of president and vice presidents. 1. The term of office of the president or a vice president commences on the day he or she is sworn in and assumes office in terms of section 94(1)(a) or 94(3). 2. The term of office of the president or a vice president extends until a. He or she resigns or is removed from office, or b. Following an election, he or she is declared to be re-elected or a new president is declared to be elected. And, except as otherwise provided in this Constitution, their terms of office are 5 years and coterminous with the life of Parliament. 96 Resignation of President or a Vice President. 1. The President may resign his or her office by written notice to the Speaker, who must give public notice of the resignation as soon as it is possible to do so and in any event within 24 hours. 2. A Vice President may resign his or her office by written notice to the President, who must give public notice of the resignation as soon as it is possible to do so and in any event within 24 hours. 97 Removal of President or Vice President from office. 1. The Senate and the National Assembly, by a joint resolution passed by at least one-half of their total membership, may resolve that the question whether or not the President or a Vice President should be removed from office for a. Serious misconduct, b. Failure to obey, uphold or defend this Constitution, c. Willful violation of this Constitution, or d. Inability to perform the functions of the office because of physical or mental incapacity. Should be investigated in terms of this section. 2. Upon the passing of a resolution in terms of subsection 1, the Committee on Standing Rules and Orders must appoint a joint committee of the Senate and the National Assembly consisting of 9 members reflecting the political composition of Parliament, to investigate the removal from office of the President or Vice President, as the case may be. 3. If a. The joint committee appointed in terms of subsection 2 recommends the removal from office of the President or Vice President, and b. The Senate and the National Assembly, by a joint resolution passed by at least 2/3 of their total membership, resolve that the President or Vice President, as the case may be, should be removed from office. The President or Vice President thereupon ceases to hold office. 98 Presidential immunity. 1. While in office, the President is not liable to civil or criminal proceedings in any court for things done or omitted to be done in his or her personal capacity. 2. Civil or criminal proceedings may be instituted against a former president for things done and admitted to be done before he or she became president or while he or she was president. 3. The running of prescription in relation to any debt or liability of the president arising before or during his or her term of office is suspended while he or she remains in office. 4. In any proceedings brought against a former president for anything done or admitted to be done in his or her official capacity while he or she was president, it is a defense for him or her to prove that the thing was done or admitted in good faith. 99 Functions of Vice Presidents. The Vice Presidents assist the President in the discharge of his or her functions and perform any other functions, including the administration of any ministry, department or act of Parliament, that the President may assign to them. 100 Acting President. 1. Whenever the President is absent from Zimbabwe or is unable to exercise his or her official functions through illness or any other cause, those functions must be assumed and exercised. A. By the first Vice President. B. Where the first Vice President is unable to exercise those functions, by the second Vice President, or C. If there is no Vice President who is able to exercise the functions, by Minister. I. Designated for such an eventuality by the President, or 2. Nominated by the Cabinet, where no minister has been designated by the President in terms of subparagraph I. 2. Except in accordance with a resolution passed by majority of the total membership of the Cabinet, a person exercising the functions of the office of President in terms of subsection 1, must not exercise the power of the President. A. To deploy the defense forces. B. To enter into any international convention, treaty or agreement. C. To appoint or revoke the appointment of a Vice President, Minister or Deputy Minister, or D. To assign or reassign functions to a Vice President, Minister or Deputy Minister, including, in the case of a Vice President or Minister, the administration of any act of Parliament or of any ministry or department, or to cancel any such assignment of functions. 98 Presidential Immunity. 1. While in office, the President is not liable to civil or criminal proceedings in any court for things done or admitted to be done in his or her personal capacity. 2. Civil or criminal proceedings may be instituted against a former president for things done and admitted to be done before he or she became president or while he or she was president. 3. The running of prescription in relation to any debt or liability of the president arising before or during his or her term of office is suspended while he or she remains in office. 4. In any proceedings brought against a former president for anything done or admitted to be done in his or her official capacity while he or she was president, it is a defense for him or her to prove that the thing was done or admitted in good faith. 99 Functions of Vice Presidents. The Vice Presidents assist the President in the discharge of his or her functions and perform any other functions, including the administration of any ministry, department or act of Parliament, that the President may assign to them. 100 Acting President. 1. Whenever the President is absent from Zimbabwe or is unable to exercise his or her official functions through illness or any other cause, those functions must be assumed and exercised. A. By the first Vice President. B. Where the first Vice President is unable to exercise those functions, by the second Vice President, or C. If there is no Vice President who is able to exercise the functions, by Minister. I. Designated for such an eventuality by the President, or 2. Nominated by the Cabinet, where no minister has been designated by the President in terms of subparagraph I. 2. Except in accordance with a resolution passed by majority of the total membership of the Cabinet, a person exercising the functions of the office of President in terms of subsection 1, must not exercise the power of the President. A. To deploy the defense forces. B. To enter into any international convention, treaty or agreement. C. To appoint or revoke the appointment of a Vice President, Minister or Deputy Minister, or D. To assign or reassign functions to a Vice President, Minister or Deputy Minister, including, in the case of a Vice President or Minister, the administration of any act of Parliament or of any ministry or department, or to cancel any such assignment of functions. 102 Remuneration of President and Vice Presidents. 1. The President and Vice Presidents are entitled to the salaries, allowances, pensions and other benefits that are prescribed under an Act of Parliament. 2. The salaries and allowances of the President and Vice Presidents must be charged upon and paid out of the Consolidated Revenue Fund. 3. A person who has ceased to be President or Vice President is entitled to receive A. a pension equivalent to the salary of a sitting president or vice president, as the case may be, and b. Such allowances and other benefits as may be prescribed under an Act of Parliament. 103 President and Vice Presidents and former office holders not to hold other office or employment. The President and Vice Presidents, and any former President or Vice President, must not, directly or indirectly, hold any other public office or be employed by anyone else while they are in office or are receiving a pension from the state as former President or Vice President, as the case may be. Part 3. Ministers, Deputy Ministers and Cabinet. 104 Appointment of Ministers and Deputy Ministers. 1. The President appoints ministers and assigns functions to them, including the administration of any Act of Parliament or of any ministry or department, but the President may reserve to himself or herself the administration of an act, ministry or department. 2. The President may appoint deputy ministers to assist any minister in the exercise of his or her functions. 3. Ministers and deputy ministers are appointed from among senators or members of the National Assembly, but up to 5, chosen for their professional skills and competence, may be appointed from outside Parliament. 4. In appointing ministers and deputy ministers, the President must be guided by considerations of regional and gender balance. 5. Ministers and deputy ministers who are not members of Parliament may sit and speak, but not vote, in the Senate or the National Assembly. 6. Before taking office, a person appointed as minister or deputy minister must take before the President the appropriate ministerial oath in the form set out in the third schedule. 105 Cabinet. 1. There is a cabinet consisting of the President, as head of the cabinet, the vice presidents and such ministers as the President may appoint to the cabinet. 2. Cabinet meetings are presided over by the President or, in his or her absence, by a vice president or, in their absence, by minister referred to in Section 101C. 106 Conduct of Vice Presidents, Ministers, and Deputy Ministers. 1. Every Vice President, Minister and Deputy Minister must act in accordance with this Constitution. 2. Vice Presidents, Ministers and Deputy Ministers may not, during their tenure of office, a. Directly or indirectly, hold any other public office or undertake any other paid work. b. Act in any way that is inconsistent with their office, or expose themselves to any situation involving the risk of a conflict between their official responsibilities and private interests, or c. Use their position, or any information entrusted to them, to enrich themselves or improperly benefit any other person. 3. An Act of Parliament must prescribe a code of conduct for Vice Presidents, Ministers, and Deputy Ministers. 107 Accountability of Vice Presidents, Ministers, and Deputy Ministers. 1. Subject to this Constitution, every Vice President, Minister and Deputy Minister is accountable, collectively and individually, to the President for the performance of his or her functions. 2. Every Vice President, Minister and Deputy Minister must attend Parliament and parliamentary committees in order to answer questions concerning matters for which he or she is collectively or individually responsible. 108 Tenure of Office of Ministers and Deputy Ministers. 1. The office of a minister or deputy minister becomes vacant. a. If the President removes him or her from office. b. If he or she resigns from office by written notice to the President. c. Upon the assumption of office by a new President. 2. Subject to subsection 4, a minister or deputy minister who is a member of Parliament on appointment as minister or deputy minister vacates his or her office as such upon ceasing to be a member of Parliament. 3. Subject to subsection 4, a minister or deputy minister who is not a member of Parliament on appointment as minister or deputy minister vacates his or her office as such if circumstances arise that would result in his or her seat becoming vacant were he or she a member of Parliament. 4. Subject to this Constitution, in the event of a dissolution of Parliament, ministers and deputy ministers continue to hold office as such until the President-elect assumes office after a general election. (109) Vote of no confidence in government. 1. The Senate and the National Assembly, by a joint resolution passed by at least two-thirds of their total membership, may pass a vote of no confidence in the government. 2. A motion for the resolution for a vote of no confidence may be moved only if a. At least 7 days' notice of the motion has been given to the Speaker, and b. The notice of motion has been signed by at least half of all the members of the National Assembly. 3. A motion for a vote of no confidence a. Must be debated in a joint sitting of the two Houses of Parliament within 21 days after the Speaker received the notice of motion, and B. Must be voted on within 7 consecutive sittings after it was moved. Otherwise it is regarded as lost. 4. Where Parliament passes a vote of no confidence in the government, the President must, within 14 days after the vote, A. Remove all ministers and deputy ministers from office, unless they have already resigned as a result of the resolution, and appoint persons in their place, or B. Dissolve Parliament and, within 90 days, call a general election. 5. If the President does not act in accordance with subsection 4, within 14 days after the passing of the vote of no confidence in the government, Parliament stands dissolved. Part 4. Executive Functions. 110 Executive Functions of President and Cabinet. 1. The President has the powers conferred by this Constitution and by any act of Parliament or other law, including those necessary to exercise the functions of head of state. 2. Subject to this Constitution, the President is responsible for A. Assenting to and signing bills. B. Referring a bill to the Constitutional Court for an opinion or advice on its constitutionality. C. Summoning the National Assembly, the Senate or Parliament to an extraordinary sitting to conduct special business. D. Making appointments which the Constitution or legislation requires the President to make. E. Calling elections in terms of this Constitution. F. Calling referendums on any matter in accordance with the law. G. Deploying the defense forces. H. Conferring honors and awards. I. Appointing ambassadors, plenipotentiaries, and diplomatic and consular representatives, and J. Receiving and recognizing foreign diplomatic and consular representatives. 3. Subject to this Constitution, the Cabinet is responsible for A. Directing the operations of government. B. Conducting government business in Parliament. C. Preparing, initiating and implementing national legislation. D. Developing and implementing national policy, and E. Advising the President. 4. Subject to this Constitution, the President may conclude or execute conventions, treaties and agreements with foreign states and governments and international organizations. 5. A decision by the President must be in writing if it is taken in terms of legislation. 6. In the exercise of his or her executive functions, the President must act on the advice of the Cabinet, except when he or she is acting in terms of subsection 2, above. 111 War and Peace. 1. The President has power to declare war and make peace, and must advise the Senate and the National Assembly within 7 sitting days after exercising such power. 2. The Senate and the National Assembly, by a joint resolution passed by at least 2/3 of the total membership of Parliament, may resolve that a declaration of war should be revoked. 3. Where Parliament has resolved that a declaration of war should be revoked, the President must take all practical steps to disengage from the war, taking due account of the need to ensure the safety of Zimbabwean personnel and equipment. 112 Power of Mercy. 1. The President, after consultation with the Cabinet, may exercise the power of mercy, that is to say, may A. Grant a pardon to any person concerned in or convicted of an offense against any law. B. Grant a respite from the execution of a sentence for any offense for an indefinite or specified period. C. Substitute a less severe punishment for that imposed for any offense, or D. Suspend for a specified period or remit the whole or part of a sentence for any offense or any forfeiture imposed in respect of any offense. And may impose conditions on any such pardon, respite, substitution or suspension. 2. Where a person who is resident in Zimbabwe has been convicted in another country of an offense against a law in force in that country, the President may declare that the conviction is not to be regarded as a conviction for the purposes of this Constitution or any other law in force in Zimbabwe. 3. The grant of a pardon or respite from execution of sentence or the substitution or suspension of a sentence must be published in the Gazette. 113 States of Public Emergency. 1. The President may by proclamation in the Gazette declare that a state of public emergency exists in the whole or any part of Zimbabwe. 2. A declaration of a state of public emergency ceases to have effect after 14 days beginning with the day of publication of the proclamation in the Gazette unless, before the end of that period, the declaration is approved by at least 2/3 of the total membership of Parliament at a joint sitting of the Senate and the National Assembly. 3. If Parliament is dissolved during the period of 14 days after a state of public emergency has been declared, The declaration ceases to have effect after 21 days, beginning with the day of publication of the proclamation in the Gazette, unless within that period the declaration is approved by a majority of all the members of the new Parliament at a joint sitting of the Senate and the National Assembly. 4. A declaration of a state of public emergency which has been approved under subsection 2, or 3, remains in effect for 3 months from the date on which the proclamation was published in the Gazette unless it has earlier been revoked or ceased to have effect under this section. 5. If a declaration of a state of public emergency is not approved after consideration by Parliament, or if for any reason it is not considered by Parliament within the period specified in this section, the President must, within 7 days, by proclamation in the Gazette, revoke the declaration. 6. If, by resolution passed by a majority of the members present at a joint sitting of the Senate and the National Assembly, Parliament resolves that a declaration of a state of public emergency a. should be continued for a further period not exceeding 3 months, the President must without delay, by proclamation in the Gazette, extend the declaration for that further period. b. should be revoked or that it should apply within a smaller area, the President must without delay, by proclamation in the Gazette, revoke the declaration or provide that the declaration relates to that smaller area. 7. The Constitutional Court, on the application of any interested person, may determine the validity of a declaration of a state of public emergency. b. Any extension of a declaration of a state of public emergency. 8. Any court may determine the validity of any legislation enacted, or other action taken, in consequence of a declaration of a state of public emergency. Part 5. Attorney General. 114 Attorney General. 1. There is an Attorney General appointed by the President. 2. A person who has been appointed as Attorney General assumes office upon taking before the President, or a person authorized by the President, the oaths of loyalty and office in the forms set out in the third schedule. 3. A person is qualified for appointment as Attorney General if he or she is qualified for appointment as a judge of the High Court. 4. The functions of the Attorney General are a. To act as the principal legal advisor to the government. b. To represent the government in civil and constitutional proceedings. c. To draft legislation on behalf of the government. d. To promote, protect and uphold the rule of law and to defend the public interest. And e. To exercise any other functions that may be assigned to the Attorney General by an Act of Parliament. And the Attorney General may exercise those functions in person or through subordinate officers acting under the Attorney General's general or specific instructions. 5. The Attorney General may a. Attend cabinet meetings, but has no vote. b. Sit and speak in the Senate and the National Assembly, but has no vote. And c. With the leave of the court concerned, appear as a friend of the court in any civil proceedings to which the government is not a party. 115 Removal from office of Attorney General. The President may at any time remove the Attorney General from office.